Okay.
I think we're live.
I think we are. Okay.
Somebody send a thumbs up if you see us.
Somebody tell us you can see it on both Little Girls Attorneys video and mine. Lauren. Okay. So you can see it on both accounts. Someone just say, yes, we can see it on both accounts.
Someone give us a thumbs up, something. Yes. Okay, cool.
Okay.
Woo, we're live. Yay. Hello, everyone.
Hi.
It took us a second, but we are here and we're getting better at this. So that's good news.
We're working on it. We are working on it.
Thank you for your patience. So it is late here. It's like 5. But we attended the hearing. It was a long hearing. It was what, 2.5 hours?
Well, we took a break in the middle, but yeah, it was a long one.
So let's set the stage. So we got there a little bit before the time of the hearing, maybe an hour. And there were some other content creators there, some members of the public, some people that are, following the case that are local. We went through security. We went into the courtroom, and we also
better changing to a better microphone.
Can you hear us better?
That should be better.
Good call. Okay. Hopefully that made it better.
Hopefully.
Okay. So who was in the courtroom? There were a ton of people in the courtroom. There were maybe like 10 or 15 lawyers on each side, and they were all in the courtroom. There were potentially some paralegals. There were potentially some law clerks. I counted at least, 1, 2, 3, 4, 5, 6, 7 attorneys on Lively's side, and then another 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 on the Wayfair side. But we also didn't know who everyone looked like, so I could have missed people. This was just based off of their telling us who they were when the judge showed up. So the hearing started around 9:40 in the morning, just 10 minutes after, and the courtroom was full. Packed. I mean, I've never seen a courtroom that full in a minute for a civil case. Okay, so where should we start with?
I have just some general random stuff I wrote down. Okay, so here's some things that are not exactly legal, but anyway. So she was just saying, when you look around the room, that was like a $25,000 an hour room, because every single lawyer in there is getting paid, and even the associates and the baby lawyers, and every single person we've ever seen their name on anything is it was there. So it was a very expensive morning for both parties.
Yeah.
The only person that we saw that we really knew who wasn't actually up there arguing was Sigrid McCauley. She was there. She is very blonde. Just leave it at that. But it was a very expensive hearing. You could tell, and we'll talk more about it, but you could tell that it is a very different matter to write something in paper than to stand up in a room full of people and defend it. And a lot of them were actually quite nervous. Even though they do this for a living, you could tell, some of them were visibly very nervous. The stakes were really high. And like she said, the room was absolutely packed. So even for these people who do this all the time, it was a lot. I need you guys to know, number one, this one has about the best handwriting I've ever seen in my life. I looked over and I was like, is that your handwriting? It's like a font. Just so you know. Also, Katie from KC in person is like a supermodel.
Stunning.
She's very tall, but she's stunning. Absolutely stunning. And the other thing is, we'll tell you about all the people that we saw. We did meet some of the lawyers. None of the Lively lawyers wanted to talk to us. But most of the Baldoni lawyers did. And that was fun. But you want to do some just general thoughts on style?
Yeah.
Okay, we'll go ahead and start.
Yeah. So I thought, so both sides split up the arguments, meaning that they picked 3 attorneys to split up who's going to argue what. And each lawyer has a very, very different argument style. The nervousness is across the board. I think we can safely say every single lawyer arguing. And that's been my experience too. It's a nerve-wracking thing.
You never stop with the nerves.
And, the judge allowed for 1 hour for each side to argue their case. And so they split up the arguments. So, for example, Attorney Bach argued about harassment, retaliation, and the distinction between employee and independent contractor. Shapiro focused on defamation and contract claims, and then Ellen Garofalo focused on MJOP and spoliation. So across the three of these, for the Wayfair defendant side, I'll just speak to because my notes are right here open to it. They were each very, very different in how they approached it. And what the judge had previously asked the parties to do was to focus in on the most salient arguments. He didn't want the parties to rehash their papers. He wanted them to narrow in to the things that he was most interested in. And for the most part, he allowed them to start speaking at the beginning, but then he would go right into deep questions and really pegging the issues. Where is the issue of fact here? Can we determine if there's an issue of fact?
Yeah. I think, first of all, just to set the scene, like he's up on a dais that's a little bit heightened, but not terribly, but he's up high. And then his like courtroom person is in front of him. All the lawyers were at tables. And there were so many there were like people who were carrying boxes, right? It was just, there were tons and tons of people. And then we were all back in the gallery, but whoever was talking at any particular time went up to a podium, and that podium had a microphone. So they would switch. Mm-hmm. I think the one thing that we have discussed many times already today that we want to make sure everybody knows is how unbelievably prepared this judge was.
Incredibly prepared.
He had read every document. He knew the cases. He knew the evidence. His questions were not like, what case is this again? Sometimes that happens. He was incredibly well prepared. You guys, this is a very good judge.
I have to say, I've argued motions for summary judgment before federal courts and state courts, and they often do read the papers. But in a case like this, when there are literally hundreds of pages of documents, he knew exhibits by number. He knew exactly what was inside of exhibits. This guy was prepared, meaning that they had done the work. Him and his clerks had done the work to not only read the relevant case law, but to me, and I don't know what you think about this, to me, it sounded like they had already kind of drafted up a mock opinion. And this is very typical for courts to do, although it's more typical in an appellate level and a higher up level. But it sounded like they already had like a structure of where they thought the order is going to go, because he knew everything inside and out. And that's a really good sign. He wasn't just sitting back and taking in the arguments. He was narrowing in to ask the parties specific questions to determine where he was going to fall on issues.
Yeah, he would say like, tell me about the Gravequick case. There's hundreds and hundreds of cases in these filings. And he was like, I want to know about this one. Tell me about how this one deals with this one with this court. Like somebody had prepared him, and then he had prepared himself to zero in. And that there were a lot of instances of it that I'm sure we'll talk about. But there were many, many times when a lawyer would be up there talking about something, and he would go, I don't want to hear about that. I got that issue. Don't talk about something else. So I think you're right that there are some things where he's like, I've seen enough. I don't need to hear your argument on that. And then he would push them towards, This is what I want to hear. This is what I want, which gave us, I think, some indication as to where he is.
At one point, I can't remember which argument it was. Maybe it was Garofalo, but to the point where she was going to reference a decision that came out in December of 2025. So after the parties had already briefed all of this, and he was like, no, stop right there. I know which case you're talking about, and I don't need you to tell me about it. So it showed to me that he's also done the relevant research on the specific issues to be up to date with the cases that are coming out. So this order that's going to come out, or orders that are going to come out, are going to be massive. They're going to be very, very big, probably bigger than what we saw for the motion to dismiss.
Yeah, that's true. And I think in terms of style, like I don't want to come on here and be like, this person wasn't good, or this person, because they're all trying their best and these are all very talented lawyers. But I think in terms of like the crispness that we're sort of expecting at this high level of practice, and like somebody who really commands the moment when they have it, probably the one who did that the best was Gottlieb. Gottlieb is very confident in a way that, even if you're nervous, you can still be confident. but he did the best job of everybody. Of like, the judge would ask him a question, and instead of dancing around it, he would make sure that he answered the question. There was one time when the judge basically said to him, well, if I decide this and this, aren't your contract claims over? And instead of trying to like be like, whoa, but he was just like, yep, they are. So, that doesn't mean he necessarily made the best arguments, and that doesn't mean they'll win. But in terms of just like us being like, who did our profession the best today? He is very good. Like, don't sleep on him. He is good in oral argument. You could tell that he is used to that. And he was not as visibly, at least, nervous as everybody else seemed to be.
Yeah, for sure. I mean, most lawyers try not to answer a question by showing a weakness in their case, and he wasn't scared to do that, which actually can come off as a strength. And so while some of the arguments that they were making, I didn't necessarily think were strong legal arguments, the way that they presented them came off as pretty strong. Like, I think, for example, Hudson is one that comes to mind, where she was very bold-faced making arguments that I would never make on a case like this, because I just don't believe that the law supports those arguments. But she was doing it so confidently and comfortably that you almost believed her. At the end of the day, this kind of doesn't play that much into the judge's decision. The judge is going to look at the law, and the judge is going to look at the facts. So we're just kind of giving you our impression of what the lawyers came off to the rest of us.
It's just, the style of the thing. I said yesterday or the day before, whatever, somebody is going to have to get up at a podium and say with a straight face, even though you've seen that PGA letter, Blake was an employee and Hudson was the one who did it. And we were like, I don't know that I could do it. Yeah. I don't know that I could do it with a straight face, but she did. She did.
She did.
She was not she did a good job. She comes off as much more, she was just much more approachable in person. Like, she was softer in person. I thought everybody else kind of was how they seemed to be.
Yeah. I wouldn't say there was any surprises there.
No. Should we tell them about who we met?
Oh, yeah.
Get into the argument?
Yeah.
Do you guys want to know who we talked to? You know who didn't try to come talk to us?
Hudson and Gottlieb. And here we are singing their
praises.
We're
being so nice. See?
See, we have nice things to say.
Yeah.
No, they didn't try to talk to us. But we ran into Fritz.
We met Fritz, you guys.
He's as nice as you might hope he is.
He's nice and he's cute, and he was very humble. We were like, you're like the fan favorite. And he said, oh, that's what everyone in my office is always telling me. And then, we were kind of trying to compliment like the way that you write is, everyone can understand. He was like, oh, I have really smart people around. He was very humble about the whole thing, but you could tell he also liked it.
Yeah.
And then Friedman
said
hello quickly. He looks exactly like he looks on TV.
I would say like maybe a little smaller.
That's true. He
has like a big commanding presence, but he was like kind of
He didn't say a word the whole day.
Yeah, he didn't say anything.
He just sat there, and including when they were talking about him because of the defamation claims. I think it was good for him to be there to show like, I'm not afraid of this. But, they were talking about him and whether his statements are protected by the law, like 6 inches away from
about
his face.
Him. Yeah.
But, he handled himself well.
Yeah. He didn't huff or puff. He didn't show any antics. He was calm and collected. I thought Ellen, super classy lady. Oh my gosh. Yeah. Super classy. Just really, really impressive woman. Has been litigating for a long time. So it's cool to see her.
Yeah. Yeah. If you're a Fritz fan, keep being one.
Yeah.
He was great.
And his partner, what's his name? Schuster?
Mitch Schuster. Oh, he was super nice too.
He was super nice. And we talked a little bit about how it's really important to, break down these legal concepts in a way that everybody can understand, which is what our goal is with our platforms, is to try and make it so that it's accessible. And he was making the point that, like there's a jury, and a jury is going to need to understand these difficult concepts. And it's so true. So, thank you guys for helping us do this.
Thanks. What do you want to do? You want to go in order? Or
I guess. I mean, should we go by claim?
Maybe.
So the way that it went was each side had an hour, and then they were able to reserve a little bit of time for like rebuttal. And so each side split up the issues, They would have their time. They would talk about their issues. So Bach went first. He talked about harassment, retaliation, and the independent contractor analysis. And then when he was done, then the next lawyer of Wayfair's team would go up. So then once the entire, Wayfair lawyer team went, then it turned over to Lively, and they went through this sort of similar breakdown. Yeah. So we kind of got a piece of each of the claims, throughout the morning.
I think one of the things that surprised us both was where Wayfair started. They started with sexual harassment, and they started with sexual harassment being argued by Bach. And that was we didn't expect them to start with sexual harassment, because that is one of those issues that is more likely to be a fact issue, right? We thought they would argue more of the purely legal issues. Yeah. And I just thought, the team for Wayfair was 2 women and a man, and then 1 man was the guy who argued sexual harassment. And so at the beginning, it was a little bit not strange, but it was just like he was the one who went up there, and he's like this very learned professorial guy with red hair with the glasses down like this. And he's up there talking about how, these are just trivial small things. These are low level things. And so I don't know, that was an interesting choice for them to make. It doesn't mean you have to have a woman go up there and talk about sexual harassment, but a lot of times people do. And so I think we were kind of surprised that it started out that way.
But I think maybe they had to.
Maybe.
Because this whole case is started with a harassment claim. And though the retaliation claim, and that part is interesting because I think it's shifted since when we first got our retaliation claim. But, since this whole thing started out as a sexual harassment claim. And so it seemed obvious to them to start, or it seemed obvious that they would start with that to say, Your Honor, the context of the workplace matters. They talked about how this is not just an office where people are pushing paper. We're talking about a movie that involved actors and actresses that are involved in adult and sexual themes, and things like this come up. And so they set the stage for, this is the context in which we're talking about the instances of sexual harassment. So
yeah, can I say something?
Yeah.
So there was a lot of argument on the sexual harassment about, there's a case from California about, I can't remember what the case is
Lyle
called.
versus Warner.
Yeah, it's about the writer's room at Friends. And it was like a sexual hostile work environment claim, and a court found there were all kinds of inappropriate things going on in this writer's room, but it was men and women, and so it ultimately couldn't be discrimination. And so both sides were trying to argue that. Bach was trying to argue this is just like that, and the Lively team was like, no, this is different. But it was very clear over the course of the entire hearing that the judge is very tuned into the fact that this is a creative workplace, and he is very tuned into we're not going to squelch creativity. He asked very pointed questions like, are you saying a director has to ask an actor every time they improvise? Because that doesn't seem right. And I think this is probably the point of the case where I know everyone got upset about it at first, but the fact that his brother is a director probably really helps, because he was very keen to say you can't stop what you're doing in the middle of doing something creative to make sure it's okay. Don't you have to have some ability to bob and weave and pivot when you're engaged in the creative and creation process? I just felt like he was kind of signaling I realize this is not an accounting office. I realize that where we are has to be part of it. We can't tell where he's going to land. Mm-hmm. But he communicated, I thought, he said the word creative a bunch of times.
Yeah. And some of his questions were rooted in that. So, for example, when Hudson came up, Hudson argued the harassment claim for Lively, and she identified 4 instances where they believed it to be severe or pervasive, and she argued that each of the individual instances in and of itself give rise to a harassment claim because they involve touching, and she centered it around the idea of consent. And the fact that if, there was kissing or nuzzling was the word that was used without consent, or the showing of any type of nudity without consent. The third one was, I guess this didn't involve touching, but kind of staring, the Heath staring allegation. And then the last one was the filming of the birthing scene without consent. So those were the 4 kind of instances that they believed were severe or pervasive. And the judge asked, does the director have any ability to improvise? Or does every time they go off script give rise to a FIHA claim? And that's a really good question. Like, where is the line? What is the barometer for determining whether or not there's consent? And so there was some discussion about how the nudity writer, or was it the nudity writer? Yeah, the nudity writer defines these things, and it's all okay as long as she has consent. But that was something that he really pressed on, because like, practically speaking, how do you run a movie set that involves these types of scenes without accidentally violating FIHA, essentially?
I thought one of the best questions of the day that he asked was during this time, and she was talking about consent, which we were pretty confused by, because that's an assault term that doesn't usually come in harassment. But he made this really good point of saying, okay, if every time something happens on a set that hasn't been expressly consented to, it's a violation of the sexual harassment laws, what do we need these writers, these nudity writers, for? What do we need intimacy coordinators for? If this stuff violates the law just by the fact that they didn't consent to it, which is the argument that they're making, isn't all this stuff moot? Which I thought was a really good point. And I think, again, that showed his insight into, like, if you want me to put the line where you're arguing the line should be, that changes the whole way that all of this works. And he asked her many, many times, where is the line? You're saying that it's right. And that was really hard for her to answer. And she's doing her job, which is to say, well, a jury should decide that.
Yeah.
But he made it very clear, both when he was questioning Lively's attorneys and Wayfair's attorneys, that, like, clearly somewhere on this spectrum it is harassment, and somewhere on this spectrum it's not. And the question that you guys are asking me to answer is, where is the division? And neither one of them really gave us super clean.
No, there was one point I wrote down that he asked a really specific question about where is the limit. He said, for example, if there's a dance scene and the director is having the hand put on one part of the back, but then directs to put on another part of the back, does that require specific consent? And if specific consent is not obtained, is your proposition then that all direction of a director needs to be decided by a jury?
Yeah.
And that's essentially the proposition that they're putting forward by this argument, and one that I don't think that he bought. I don't think he bought it.
The biggest revelation to me, or the biggest sort of concession that Hudson made, and like I said, she argued some stuff that we were both like, I don't know if I could do that. And she didn't do it, like, rudely. She just was like, I'm going to stand on this. The judge got her to admit that if you're calling somebody sexy and hot because you're talking about parts of the movie, you're talking about their costume, or you're talking about their character and not them as a person, and you're the director, that's not sexual harassment. He got her to say, because he said, well, if they're the director and they're directing the character and they say sexy and hot, is that okay? And she said, that's okay, which I thought was shocking. I couldn't believe she admitted that, which means this all comes down to, when was he a director and when was he an actor? Especially in that dancing scene where he was both.
Mm-hmm. Which makes it really difficult. And remember, the goal for the plaintiff in this scenario, in a motion for summary judgment hearing specifically, is simply to create a question that a jury needs to decide. So a he said, she said moment here. And all they really need to do is be like, well, Your Honor, it's up to the jury to decide, like, whether it's this or it's that. But a lot of these questions are actually legal questions. And that's what he was pressing on, is where is the limit, and what is... They talked a little bit about the subjective standard and the objective standard, which kind of comes in more on the retaliation piece, but Wayfair focused on the fact that it needs to be severe or pervasive. And so they talked about how there wasn't severe or pervasive incidents of this.
Right.
And Lively's team came back and said, well, at least 3 of the instances were in and of itself, just the one instance was severe or pervasive severe enough to not require pervasiveness. Because remember, severe or pervasive is a scale. You either have really severe and don't need it to be pervasive, or you have it not that severe and need it to be pervasive. And so they were trying to apply the scale in the way that it fit them the best for that particular thing, which I thought that was kind of interesting.
Yeah. Wayfair has multiple arguments to try to knock out one of the elements of sexual harassment. And you only need to knock out one for that whole claim to go away and for there to be summary judgment entered, right?
Yeah.
So they had multiple, they had severe or pervasive, they had based on sex. One of the funniest parts of the day was, it was actually a really good moment. Bach was in his rebuttal, and because they were talking about, you know, how do we know this is based on sex? And it's not just because she was the actress in the movie that was being directed. And he said, let me give you an example. And he mentioned heated rivalry. And he's like, what if one of the guys in heated rivalry did a kiss he wasn't supposed to do? Would that be a violation of discrimination law or not? Because they're both men, which was, I think, a really good illustration. And so if they can knock out any one element of sexual harassment, that's judgment in their favor. And they gave him a bunch of different options. Oh, the subjective part, that was good.
Yeah.
Talk about that.
Trying to find it where it was in my notes.
Long story short, they talked about, you know, all these different elements of sexual it must have been on the rebuttal too.
Yeah,
he said, don't forget that the severe or pervasive under the sexual harassment standard has to be severe or pervasive both objectively to a reasonable person, but also subjectively to the person themselves. And he said, when it comes to the Jamie Heath and the trailer thing, Blake Lively testified that she was not bothered. She knew he wasn't trying to look at her naked. So if she subjectively didn't believe it was severe, then the rest of it doesn't matter.
Exactly, because by her own admission, she said, I know you weren't trying to cop a look. So for that instance alone, there's no subjective harassment because she admits that she didn't believe it to be harassing. The thing about the gender basis element of this, and if it's helpful to clarify, is that all of these things could be icky, could be weird, could be uncomfortable, but they have to be based off of a protected category. And so that was something that the parties were arguing, and that's where the heated rivalry comment came into play. So would it have been the same comment towards a man? You know, I think it was in the rebuttal that Wayfair says the comment to Isabel Ferrer, for example, that wasn't to her because she's a woman. It was to her and a male actor together. So the comment that is being alleged as harassing commentary was actually not based off of gender. It was not based off of female gender, which is what Lively is claiming, that all of these statements are gender-based.
Yeah, and the judge noted, and we've both been screaming about this for a while, about does it matter what happened to Jenny Slate? Does it matter what happened to Isabella? And the judge made it clear that, like, that doesn't go into whether it was severe or pervasive. If Lively didn't know about it when it happened to her, it could go into whether it was based on sex if it only happened to women. But, you know, I know there's been a lot of internet talk. We've seen it about now it's, you know, now I've seen a dozen women, whatever. In terms of the law, whether you can utilize that it happened to another woman as part of proving that it happened to you is incredibly complex and nuanced. And he kind of said, here's what I'm looking at. And he basically said the fact that Miss Slate or Miss Ferrer may have had a similar experience may not matter, and it may not. But it cannot go into whether it was severe or pervasive for Blake if it happened to somebody who's not Blake. I really liked hearing him say that because obviously we know it's the truth, but people don't seem to get that.
And he was really specific. He asked Hudson, give me the evidence of which instances she was aware of when they happened. And that's where she struggled answering that, because she said, well, Jenny Slate comment and Isabel Ferrer. Couldn't elaborate on the Isabel Ferrer comment because it didn't happen during the time that she was there. Because as the Wayfair attorneys in the rebuttal pointed out, Lively wasn't there when Ferrer was filming her scenes and when that maybe comment would have happened. And so I think that was a pretty important point that signaled where the judge is headed on that piece.
trying to think of all the things that weren't discussed today. So no one said Ryan. No one said Van Zandt. The amended CRD, the whole It Ends With Us movie LLC thing, the judge raised it in like another question to when they're talking about the contracts, to let us know that he knew. He said, so the offer letter, which is between Blakel Inc. and It Ends With Us LLC. So he knows, but nobody argued it and he didn't ask. Mm-hmm. So we don't know if that's because he's already decided or because he doesn't care.
No Taylor Swift.
No Taylor.
Yeah. No, there were quite a few arguments that we saw in the papers that didn't appear in the hearing. That doesn't mean that they're throwing them away or that they're irrelevant. It means that the sides determined that those arguments they speak for themselves on paper with the evidence, and they didn't want to waste their time in the court to discuss them. Like, for example, we didn't see Wayfair discuss that maybe Lively's claims under Title VII are untimely. Maybe she cannot bring them anymore. We did hear them talk about, some interesting shifts in the retaliation claim that we can go to. But there were many arguments. Just want to point out that if you were following along on Twitter or whoever is reporting on it, if you're hearing that certain things didn't get talked about, I don't think the correct interpretation is that they didn't think it was important. It's that they thought that this is pretty clear on the papers and the judge is going to want to hear the other stuff. And so that's why it wasn't discussed.
Yeah, that's fair. One of the things that we heard multiple times today that's pretty typical, but I think we want to kind of explain why people say it, is the term, the totality of the circumstances. This was an argument that was made by Lively's team, both for the sexual harassment and for the retaliation. And that's what you do when there isn't like one or two clear pieces of evidence. Like, I can point you to this, and that's how you know I have evidence for this claim. They say, well, it's a totality. It's everything. And that's what they're supposed to do. They're doing their job. And I don't know about you, but I certainly include that in an awful lot of letters that I write, right? Because you want to be able to use all of the facts. But, especially on the retaliation, that was really troublesome for them because the judge was like, but what's the adverse, help me understand. And they'd be like, well, it's everything. It's the fact that she wouldn't go to he couldn't go to the premiere. She wouldn't be on the it's like everything. And to me, when someone says, well, it's the totality, to me, that's a weakness. I don't know about you, but I heard that as like, we don't really have anything to explicitly point to. So we're just going to say, I don't know, here, it's everything.
Yeah. On the retaliation piece, this thing that struck me the most was a sort of pivot that they made about what the protected activity is and how they're tying the causality piece of it. So the judge really drilled into them on this. Like, what exactly was the protected activity? Because remember, a retaliation claim can survive if there's no harassment claim. A lot of people miss that. You can still have a retaliation claim. All it has to be is there has to be a protected activity, which is defined in the law. And then there has to be an adverse employment action as a result of that or in reaction to that protected activity. So he was really trying to get them to narrow down to what exactly was the adverse or was the protected activity here. And I thought that it was interesting that Lively's attorney said, well, her adverse or her protected activity was at the premiere or right before, the timing of it is unclear, that she said she refused to take pictures with Baldoni. Full stop. That was my understanding of what she says her protected activity is. And there is a concept within this jurisprudence that if you protest illegal actions by your employer, that could constitute a protected activity. Think, for example, like an employer is telling you, you have to go on a date with X person. And you say, I protest, I will not go on a date with X person as an employee. So that act of protesting against the illegal act, that would constitute a protected activity. They were trying to say the very fact that she refused to have pictures taken with the director of this movie was in and of itself enough to constitute a protected activity from which Wayfair retaliated. as a result of her refusal to take pictures with him, they went and smeared her name. That's what I understood their argument to be.
And I think we were all kind of like trying to fix our face in that moment. I mean, the reason that you want them to be, so you want the adverse action to be as close to the protected activity as possible, because the further away they get legally, the harder it is to prove that one caused the other, right? Like if someone complains about you and you don't retaliate against them for 8 months, it's like, well, how do you know that had anything to do with the complaint? And so they want to get it closer to the smear campaign, the premiere. But I remember writing it down. I wrote it down in quotes that when the judge said, what's the protected activity? Hudson said, it's a variety of things. And I've never in all of my years of practicing discrimination law ever heard that before. And then just to add on to what LGA was just saying, I thought a very astute question from the judge also. He said, you're not arguing that by telling the press that he sexually harassed her, that's protected activity, which I thought was really important. Like to be protected activity under the law, you have to complain to somebody who can do something about it. And so he was like, you're not arguing that by telling the Daily Mail that was protected activity. And she kind of had to walk that back. Yeah. He very much gets, whether it's his brother or his life or whatever, he very much gets like the Hollywood specific parts of this issue. He knows. He doesn't think this is all, this is the same as a regular office. You could tell by his questions.
Yeah, and I think he's also does a good job of parsing out PR versus like actual employment actions that done by the employer, because his questions were really, really direct in that regards. And it didn't seem that he was persuaded that some of those actions constitute protected activity. And the reason why, and we just to reiterate, the reason why is that too much time has passed from this like 20 whatever number document.
Go get ice so we can have water.
Yeah. The amount of time that has passed from the protections email. I think the protections email was in November of 2023. And then you have the retaliation claim coming in many, many months later. So they couldn't say that in retaliation for setting the protections document back in whatever date, this is what Wayfair did to retaliate. That's too much time. It breaks the causality. And think about it, that makes sense. Like if you raise your complaint and then you even by your own admission say that like things are fine, how are you going to say that actually this thing that happened to me many, many months later proves that, or it was in retaliation for this thing that I raised last year? So they had to pivot that, it seems like. And this is the first time I'm seeing that they're really narrowing in on the protected activity being around the time of the premiere. And that the adverse employment action was this alleged smear campaign that happened as a result of her refusing to take pictures with him. What else can we talk about?
What's the thing that was funny when he said about the retaliation, like, oh, that wasn't very effective?
Oh, so they were talking about bad mouthing, and the judge was asking what evidence of bad mouthing do they have like a retaliation claim for? Like where is that protected activity? And they respond that there was a meeting with Colleen Hoover and Jamie Heath and Justin Baldoni, in which they apparently talked about Lively and raised some of the issues and some of the harassment issues that she raised. And Ezra Hudson said that, Colleen Hoover, this esteemed author, was so turned off by these commentary, this bad mouthing, that she said, I never want to have anything to do with them ever again, and didn't talk to them. And the judge said, well, it sounds like that act of retaliation was not very effective.
Yeah, it was a funny.
Thank you for the water.
Yeah, you're welcome. Yeah, he was, I don't know. I think he's trying to figure out, if I enter summary judgment and end this case for this very high profile, female Hollywood actress, like what signal is that going to send? And he wants to make sure that if he does that, it's not going to get overturned and that there's good reason for it and all that kind of stuff. But he was clearly I don't know if he had questions in front of him.
Yeah.
But it kind of looked like maybe he did.
Yeah. He was ready with his questions.
Oh, yeah.
And at times he wouldn't allow the lawyers to go on with their arguments, which is very common, by the way. Most often when you go to these hearings, you prepare your side, you expect to make your points, but you expect also to never get through them because the judge is going to direct the questions the way the judge wants to. And that's because they're trying to prepare their order and they have specific things that they're interested in.
Yeah.
So
one overall thing that we started talking about when we were eating is he really wasn't terribly open to the argument that the actor loan out agreement is an enforceable document. He was open to it like this. He was like, well, tell me what provisions were still being negotiated. But there were way more times that he was like, well, assuming I find that unsigned agreement is enforceable. Well, assuming I find that unsigned agreement isn't enforceable. And he talked a lot more about the offer letter, which is like the only one that everyone agrees is a contract.
Yeah.
He talked about that as if it is absolutely an agreement. Mm-hmm. But everything else, the ALA and the rider, he was like, I don't know. And he made them sort of, especially Gottlieb, he really made Gottlieb like, explain this to me. And that was a really interesting part, actually, was when he asked Gottlieb, so whether the rider can stand on its own, even if the ALA wasn't signed, it's this really wonky contracts issue, right? Because it's basically an addendum. And if the contract doesn't exist, then the addendum to the contract doesn't exist, right? Unless it's its own contract. And for every contract, there has to be consideration, meaning both sides give something and both sides get something. And one of the arguments that Wayfarer made is that there wasn't any consideration for that rider because the only thing she agreed to do was to continue acting in a movie she was already contractually required to act in. And the argument that Gottlieb made was what she gave up her right to have a formal HR investigation. But then that kind of fell apart. Yeah.
Yeah. Because the judge said, well, at first the judge asked, what was the forbearance? What did she forbear? Oh, her right to seek a claim. And then Gottlieb said yes. And he's like, well, isn't that why we're here? Which was another funny.
It was funny.
And then Gottlieb walks that back. No. The forbearance was the right to a formal HR complaint. And I thought that fell flat and nobody really picked that one up because you're saying essentially that she gave up her right to have this properly dealt with in the workplace, which is a requirement when there's a policy to go through it in the workplace, but didn't give up her right to then sue about it. So what did she actually forbear?
Right.
You can't forbear on behalf of the other side. You have to forbear something for yourself. And so I don't think that argument works.
I know you guys are asking in the comments already, and we can talk about it, but like on the independent contractor versus employee thing, they got really deep into that. That he wanted to talk about that a lot. And one of the things that I was kind of shocked by is that Ezra Hudson said, actors are hardly ever independent contractors because they speak lines written by someone else, right? And I just thought, like, if I'm Lyman and I hear that, I'm like, do I really want to make a ruling is that what actors want? Because they were going back and forth. She was arguing that Lively's an employee because, they told her when to show up and what the shoot days were and when she had to be in hair and makeup. And then the other side came back and were like, yeah, because she negotiated when she was going to show up and when hair and makeup were going to be, right? But I thought that was a weird statement because he was like, does that mean all actors are employees? And she's like, yeah, basically.
Yeah, she basically said that. Mm-hmm. I mean, there was one case, and I can't remember which case it was that she referred to, but it involved an actress. And in that particular case, it was determined that that actress was an employee, and she really wanted the push to the judge to be like, well, this is an issue that the jury should decide. Meaning, judge, you shouldn't decide on this because it's a fact issue that needs to be refuted. And the judge pushed back on that. It said, well, actually, like, what are the facts here? Like, what did she have control over? And then you have the PGA letter, which in her own words shows and displays that she had ample control over every element of the production of this film and post-production of this film. And there was a question that he asked, I think it was in the rebuttal. He asked, like, what was there anything that she asked for that Wayfarer didn't give her?
Yes.
And they couldn't name a single thing. No, she got everything that she wanted. So where is the control? Because part of the analysis is also, can you negotiate your terms? Can you negotiate the things that you want? And that is an element of power and control, which is essentially fundamentally what the distinction between a contractor and an employee is.
Yeah, the Lively's team is focusing pretty heavily on this case about this ballerina, where it was found that she was an employee, even though she had some control over like her wardrobe and her dance and stuff. And that's, how we should look at creative people. But I thought that the Wayfarer folks did a pretty good argument of being like, she doesn't get to say where the ballet building is. And she doesn't write a letter talking about how it's basically her ballet. Mm-hmm. So I thought they did a pretty good job of distinguishing that. But that's one of those, like, if the judge were to decide that Lively was an employee for whatever reason, he would want to do that incredibly narrowly. Mm-hmm. Because he does not want to make a decision that affects every other actor in the industry. I think he's pretty sensitive to that.
And I don't think he really wanted to push this to the jury, because he said something to the effect of, well, when the argument was made by Hudson that the control is an issue of fact for the jury, he said, well, if no reasonable juror could find that there was control or no control, then the MSJ needs to be granted on this. Yeah. And so that is part of his inquiry is, could any reasonable juror find this? Is it reasonable for a juror to find this? And that's something that appeared to be very clear to him on that. So I think the PGA letter, as we suspected, is actually quite damning for her in that sense. I don't know that she's going to be able to win on this piece, but we'll see.
It's a hard argument to make, and then it's a hard argument to make having all of the also there's a contract, also there's FEHA. Like at one point the judge I think it was right when she started. Yeah. The judge flat out asked Hudson, what do you need FEHA for?
Yeah.
Like, you're up here arguing about Title VII, saying that she's an employee. Why do you need FEHA? And to her credit, she said, because I can get more damages under FEHA than I can under Title VII. I mean, to her credit, she didn't lie.
Being honest.
But I think that too is an indication that he sees like there's a lot of duplication here. Mm-hmm. Obviously, you don't need all of it. But I also think that it's the PGA letter is a big part of it. The Lively people wanted to talk more about like how she was paid and like, but they didn't get into the finances really deep. Nobody got into like, because he say like you can be a W-2, blah, 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 blah. They didn't really get into that all that much, which to me means he's not focused on the structure. He's focused on the way it actually went down. And if the way it actually went down is the standard, then I think the PGA letter is really hard for her.
Yeah. Yeah. I think that he was unconvinced by Lively's team's arguments here. I mean, they kind of ended with the fact that Baldoni/Wayfarer had something to give in those instances in which she had asked for things shows that they had control. But that doesn't actually make any sense. I mean, how do you take then when, how do you take anything then?
How is anything?
Yeah.
Well, I leaned over and I was like, if somebody doesn't say on rebuttal, if she's not an independent contractor, I don't know who is. And nobody did, but Bach did say, he was talking about Title VII and about the realities test of control. And he said, this is another quote I wrote down, that PGA letter could not be a stronger trumpet. Mm-hmm. Which is like, dude, it's not that deep. You just have to look at this one letter. You don't really need to go any further. talk about all the defamations.
So that was the independent contractor stuff for the most part. I think we covered that. We talked about the retaliation. So next is what the defamation
Or
stuff?
extraterritoriality.
Extraterritoriality. That word. This is a very complicated. Everything about it is complicated. I mean, essentially what Lively wants is for this federal court to be making decisions on California law. And so extraterritoriality is this concept that state laws do not or should not necessarily apply to citizens in other states. Because if we had a system where that was the case, it would be chaos. And so one of the things that Judge Lyman questioned Gottlieb about, because I think that was Gottlieb's argument, or that was his thing that he was talking about, was what would the legislature in California have to put into a statute like FIHA to prevent it from being applied extraterritorially? Oh my God, I'm gonna like die saying that word.
Well, it's really like it's actually kind of an interesting issue, because even if you're not in the United States, you probably know this to some degree, that in the United States, every single state is its own sovereign government, and it's only allowed to control either the people who live there or the people who are doing stuff there, right? And so it violates this principle of state sovereignty to say that legislators sitting in California that I had no ability to decide who was elected get to tell me what sexual harassment is. But they kind of got into this really dense argument about, does the statute have to say explicitly this is not intended to apply outside of California? Or do we assume that they all don't apply outside of California unless they say they do? And so the judge was going around and around about like, what is the presumption and am I having to overcome? But I agree with you. He seemed like, y'all want me to decide what the California legislature was thinking? And talk about the implications of a law. What if every film that was made that came out of a California studio, no matter where it was made, if it was made in Vancouver or New York or Chicago or Atlanta, automatically applied California law? I think that would be
think about
pretty insane.
Any employer.
Yeah.
It's not just a movie set. FIHA applies to employers.
That's true.
So you have like national employers, you have employees in different states. And just because you're an employee in Austin, Texas, means that you could then apply California's laws in Austin, Texas, and then a Texas judge is going to decide on issues of California law. Why do we even have a federalist system then?
Right.
And so I don't see the judge wanting this extra. I don't see him wanting to have to decide issues of California law because it has massive implications.
There were a couple of things that, the Lively side, being the opposition, would try to argue like, oh, well, that's a jury question. And some of them you could make the argument they are jury questions, right? But there are some things that are so purely legal, a jury can't decide it. For example, the extraterritorial application of California law. Like, you can't kick that to a jury. The judge is going to have to decide. And the only pathway for him to do that in this case is through the ALA.
Yeah.
And the ALA isn't signed. So
he was really hung up on the ALA.
He's annoyed by that thing.
Yeah. He was like, you could tell that he's really grappling with it. And to your point, what you said earlier, you pull that string and it unravels a lot of things.
Mm-hmm.
Because if you decide that it is a binding contract, everything, the implications of that, Yeah.
Well, and like for so long, like all of you guys, like the general public clocked right away, like this thing isn't signed, this thing isn't signed. And then when it came out, we were like, you're right, it wasn't signed. And so we started deciding, is this a course of conduct? And like, what is this? But none of it really fully clicked into place until we saw the offer letter, because we're like, oh, a document that says if you do this role, you will get paid this much does exist, which means you don't need the ALA for this work to have been done and paid for. It's like extra added. And he really seemed like that one, I get it. Right. And they tried to make some arguments that like that wasn't enough. There weren't enough terms in there, blah, 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 blah. But yeah, he seemed like, but I have the offer letter.
I have the offer letter and you didn't sign it. And then apparently there's a document, I forgot about this, where there's like a text bubble or an edit bubble that said something to the effect of like, we are not waiving this. And that was a condition precedent, which is just a legal term for something to make a contract enforceable.
Yeah, Gottlieb got up there and was like, you know, I think he asked when did the ALA become enforceable? Like, when did it spring into being? And he was like, oh, the minute that they started shooting the movie. And he's like, well, that's weird because there's emails from March of the next year still negotiating terms of that contract. So I don't think he's buying that.
No. Yeah, it seemed like the judge seemed to be leaning towards the negotiations after that were about amendments to the agreement, but not actually the agreement itself. And they really wanted it to be the agreement itself.
Yeah.
That part of the argument is, I mean, this part of the case is very technical and confusing. And I can understand if any of what we're saying doesn't land. Like, contracts law sucked.
Well, and also like it went to another level, which is Garofalo was arguing, and it was a good argument. It was just hard to wrap your mind around it in such a short amount of time, that she said, even if, let's just assume for the sake of argument that the California law could potentially, even if it can't apply outside of California, but we've got this provision in the after loan out agreement. She's like, let's just assume for the sake of argument for a minute that thing is a fully enforceable document. She said there's also no law that says that a contract can change the extraterritoriality of a statute. That's like a legal issue that like someone could write like a full seminar on and study that for like a year of can parties to a contract accept laws that otherwise would not apply to them depending on the way that those laws are written. And so she said, there is not one single case out there, and nobody has cited one, even standing for the proposition that a contract could change this situation, which I think was her way of saying to the judge, if you want to go out on a limb on this, you're going to be going out on this limb all by yourself. No one's ever decided this before, which was kind of like, do you really want to go there? I thought that was a really smart.
Yeah, I thought that was effective because no trial court federal judge wants to be the one that could get tested at an appellate court or worse at the Supreme Court. Like, you just don't want to be doing that. So should we go to spoliation or is there anything else?
Okay. Yeah, spoliation we'll do last because it was kind of blue. Let's see. Oh, Bach did a good thing in his original argument when they were talking about independent contractor versus employee. He was like, look, I own a law firm. And if somebody who works for me comes to this courtroom and talks to this judge about this case without telling me, that person is not my employee.
Yeah.
Right? Like, he did a good job of making it like personal. I thought that was actually really effective. What else?
Yeah, I don't think the Lively side did a good job on that piece. Like, now that we're kind of talking about it out loud more and looking at my notes, they really didn't lean into all of the ways that Wayfair had control over Lively. They were like, well, her schedule was set and, you know, when she had to show up on set was set and she was required to wear a costume. And she had to show up to rehearsals and she had to play this part. She couldn't choose to play another part. But I was sitting there thinking, like, even in the basic example that I always use of the plumber can't choose to fix the window. Like, that's not his role. His role is to fix the plumbing. So it's not a very effective argument to say, well, she couldn't play another part or she had to wear the costume or what have you, because that's kind of required for you to do the thing that you are specialized in. And I don't know how they didn't talk about how she gets around the fact that Blakel Inc. was the one that had the relationship with It Ends With Us LLC. They just didn't really go into that. I think the judge may have asked one question about that, and that was about the veto rights.
Yes.
Because he said that most employees don't have veto rights. And he went back to the offer letter there. Like, Blakel Inc. negotiated this agreement and had these veto rights, and then later made a point to get the parties to say she got everything she wanted.
Yeah.
So that just all confirms that like she was able to negotiate the terms, which is not something that typical employees have the ability to do.
Yeah, there was one weird thing. I don't know if you caught it, but I wrote it down because I was like, huh? One of the things that was cited as evidence of retaliation, of evidence of an adverse employment action, Hudson said they refused to support her PGA. And I was like, I'm pretty sure they didn't refuse because I just saw it. So I don't know if it was like they wouldn't support her PGA until they did.
Yeah.
But I thought that was weird. I'm like, but they did though.
But they can't be retaliation because they did do it.
Yeah.
So there's no, and she got it. So it's not like she's damaged because she got the PGA mark.
Right.
So I don't know what that was.
They didn't get into, by the way, the whole like Betty Buzz and Betty Boos and the Hair Caroline and all that kind of stuff. That argument that Wayfair made in the papers that I think we thought was pretty good, where they said like, okay, let's say the ALA is enforceable. Let's say that we're just going to call it a good agreement. It includes this gigantic provision that says you can't get special and indirect damages, and those are all the damages that she's asking for. They didn't go there today because I think they didn't have to, and the judge didn't ask. But they didn't get into like lost profits for unrelated companies. Hudson just did this whole, it's a variety of things. Although, was it Bach in the end? Bach or Shapiro? Somebody came back and said, oh no, it was, what's her face? Garofalo. She said, remember in her CRD, she said, this is a new form of retaliation. And it was in reference to the spoliation, like, how are they supposed to know this was coming? But I was just reminded of that, like, again, telling the judge, like, do you really want to tread new ground here? Right? Like, yes, reputation can be an issue. And Hudson tried to argue that, like, all of these things combined could hurt her reputation. But again, I think the judge is pretty keenly aware that when you're talking about famous people and you're talking about their reputation out there in the media, right? Like their personal, professional reputations, there is no existing law that says, you know, talking badly about somebody to the media or online is an adverse employment action.
Yeah, I mean, she started off by saying like this is a series of events of conduct, and when Lively complained about it, Baldoni didn't do anything to address any of the complaints. So Lively brought this protection document. And this is something that either I kind of overlooked in this case or is a new angle or new light shine onto it for me, is that protection document that they were kind of coerced to sign to have the production continue on. Remember, that document came mid-production. That had a definition of what retaliation would be. And the document said, there shall be no retaliation, and retaliation shall constitute blah, 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 blah. Now, remember, at that point, nothing had happened in terms of like an online campaign or smear or whatever. But what they're doing now is saying that document defines what retaliation is. And so, judge, don't look to the case law necessarily on what retaliation is, but look to what this protections document that they signed defines as retaliation. And to me, that just shows that they kind of had it set up, ready to go for a retaliation claim, because anything that they could fit into that provision would constitute retaliation.
Yeah. And like, that's another one of the threads that like, if she's an independent contractor, then she's not an employee. Therefore, employment action can't be taken against her. Therefore, there's no retaliation either. Right? So if she is not an employee, all of the Title VII claims are gone. Because yes, she's not covered by it because she's not an employee. So therefore, these actions can't be employment actions. And I think that the judge wants to and should consider, like, what does that mean? Right? If we're going to take sexual harassment or discrimination protections away from somebody, we need to make damn sure that that person is in a position or in a situation where, you know, that's what's fair. Because most people cannot do what she did, which is to say, well, I'm just going to make this whole workplace. I'm the boss. I'm the captain now. That meme is what we need.
And the judge kind of questioned that. He said, so the question is whether there's a contract claim from the protections document, which I thought was interesting.
Oh yeah.
Because he was saying, okay, so if this protections document is a contract, and you're saying they retaliated against under the provision of the contract, what you're saying is that there's a breach of the contract. You're not saying there's an employment retaliation. Employment retaliation is different than a contractual provision that's being violated under the name of retaliation. You cannot smush these two things together. Right. And so I think he was doing a good job separating out those two things.
I just want to say, I see this comment, you can still be sexually harassed even if you're not an employee. Under California law, you can. Under federal law, you cannot. Federal law only applies to employees.
I mean, you can, it's just not actionable.
Well, it's not legally, it's not sexual. Right. Can you still be treated inappropriately? Of course.
Yeah, of
course. But if you're not an employee, if you're an independent contractor, you don't need the protection of the law to keep your job because you can just leave.
Right.
Oh, the Damon Affleck. It's like, we were already like, how are we going to prepare for this? There's so many issues. And then like every piece of evidence in the whole entire world came out today.
Yeah.
But
which I still haven't gone through all of that.
I haven't either.
It's so much.
Nobody really talked about it in the hearing today. It wasn't really relevant except for the PGA. Maybe there were a couple of other things.
Maybe the like Ferrer Depot, Slate Depot.
Yeah.
Those like references to it. Very, very high level.
Yeah. I did say straight up to Fritz, like, I can't believe you guys have been sitting on this stuff for all this time. And he's like, yeah, like they've had it. And he's like, decisions were made not to put, I'm not saying that means that like Wayfair is perfect or that these are like the best guys ever, because everybody has faults. But this is absolute. I mean, you can see by the reaction to it, how explosive this is. And they've been sitting on this stuff. Let's say at the very worst, when did discovery end? October. They've been sitting on it since October. Mm-hmm. And I imagine they've been sitting on it longer than that. Mm-hmm. So the fact that none of this leaked out is kind of crazy.
Yeah. Well, it shows that the client held their lawyers to a high standard, held themselves to a high standard. And that's this stuff. None of it came out. I didn't see any of this unless they put it in their Exhibit A, which people have pointed out that some of it was in their Exhibit A, and I forgot. But a lot of this stuff, no one has ever seen. In fact, some of it, even the parties themselves probably didn't see because they're AEO. So I'm sure there was a shock factor on whatever days, Monday, Tuesday, Wednesday, when some of this stuff was coming out. And they're like, this is the first time I'm seeing these text messages. From either side, I would think.
One of the things that happened, I wrote like a side note, because one of the things that happened today happens a lot in hearings like this, which is you talk about an idea in the abstract, and then the judge is like, but what about in this case? Right. And so as lawyers, you take whichever side is best for you. If the facts are good for you, then you're like, in this case, this is what happened. But if the facts aren't great for you, then you talk about the concept in the abstract. And I thought that the Lively people did a lot more abstract talking than the Wayfarer people did. The Wayfarer people were more like, here is the record. Mm-hmm. The record says this. Although I will say, when the judge asked, particularly Gottlieb, like, where in the record does it say this? My man was like, page 55, line 7. Like, he had that shit written down. He was very well prepared.
Hudson, not so much.
Hudson she got snagged.
Yeah, she was not.
What was that issue where she was like,
Yeah, she was really struggling.
And people are handing up notes, sticky notes to all of them. Like, hey, you forgot this.
Yeah, the like associates were like, we're useful.
We're going to earn our keep today.
I've definitely been there where I'm like, I handed the partner a sticky note today.
And you're like so excited because you're like, I have the best idea. You write it down and they look at it and go, no.
Or they read like 2 words of it and you're like, I helped win this case.
It was me.
It was me.
I did it. We were both like, we tried not to talk, but we were like in a pretty back row so we could whisper a little bit. It is a special kind of hell to be sitting in there and thinking like, but why don't you say this? This is what I would say. Yeah. Now it's easy to be like
the gallery.
Yeah. But because we can do that. It was like, I'm like writing down, like, say this.
Yeah.
Say this. Now that's easy because I'm not the one who had to learn all of this information, right? But it is kind of strange when you're just like, you could have said this.
Yeah.
And you could have said that. And you could have said that.
We're in our relaxed back row seats, like no stress, not getting paid for any of this. Like, I would have said it that way. Well, yeah, that's nice.
Yeah, like whether you like all of these people or not, they have chosen a really, really intense career, and they do it at an intensity that, like, we certainly could not do it at this stage of our lives,
or chose not to.
Where, I mean, it is high intensity, balls to the wall, 24 hours a day. And the stakes were so high, and like, I was really surprised to see how flustered Shapiro was, because I remember she argued like a DV motion or something in Diddy. And it's like, I'd be way more scared in that, because they're talking about someone's life.
Yeah.
But the stakes are really high, and you can't plug everything into your head. There was only one situation where the judge was like, I don't have a copy of that.
It was Gottlieb. He wanted to look at a specific part of the contract or some exhibit. Yeah. And he was like, I want to see it. And people were just scrambling, trying to get a copy of it. And they got a copy of it. So I don't remember the spoliation, the attorney on Lively's side that argued it. Do you remember what his name was? Bruno. I don't remember who he is, but he seemed, he seems like maybe he's like a little bit more junior. I say that cautiously. Don't hate me, Bruno, if you're listening. But the judge really allowed him to talk a lot. And that can mean a few things. It could mean he's already made up his mind, so he's going to let the attorney run out their time and let them talk. When a judge doesn't have questions, it means that they have a decision on their side. There was a appellate oral argument I sat through where the three panel judges didn't ask a single question of either side. Literally not one question. Both sides argued, there was a rebuttal, and then they went home and they didn't ask a single question. And then they made their decision like 5 days later, showing that they had already made up their mind. It didn't really matter what the lawyer said. For the most part today, I don't think that was the case. I think there were things that the judge was really grappling with and trying to test and trying to figure out where he was going to land. But with this spoliation piece, I think we got some signal that he was not inclined to grant what they were asking for. So as like a reminder, the spoliation sanctions motion that Lively filed was with respect to signal chat messages between the months of August to December or something like that. I think there's a time frame that signal chat messages existed between Wayfair and their counsel and their whatever PR people that they acknowledged exist, but they don't have because they were ephemeral and went away forever. And so Lively brought this spoliation motion to say, we are prejudiced by not having these documents, so we should get adverse inference sanctions, which literally means you lose your case because we didn't get this evidence, meaning you are a sexual harasser. Essentially, I mean, it sounds dramatic, but essentially that's what that means, or you retaliated against. And that's kind of like the most extreme, or something underneath that. And so the judge was kind of clear that, like, I'm not going there. Like, we're not going all the way to the depths. But something that came up was, what was the kind of triggering event? Meaning, what was the thing that put the parties on notice that they needed to preserve documents? And this is a question that I know you and I deal with all the time in our work. When something comes up, when you're put on notice that there's litigation, you have a duty to preserve evidence. And they were saying that when that protections document came out, they had a duty to preserve any communication that involved Lively at all.
For real.
Even if they were talking about her outfits or her hair or her dog, like, they would have had to preserve all of that documents, which is insane and doesn't really apply here. And the interesting, like, kind of nerdy legal nuance is that protections document is talking about stuff that happened on set. So what the duty that is generated potentially from that protections document is evidence that suggests, supports, or it declines to support claims of sexual harassment on set, not a retaliation complaint or a claim, right? So the judge was really trying to pin them on what exactly is that triggering event. And they were like, well, it's broad. And the minute this protection document came out and it said no retaliation in the provision, that meant that you needed to preserve anything, any thought in your brain that you had about Blake Lively needed to be preserved. And that's crazy. I'm sorry, but it's crazy.
Yeah, and I thought that Garofalo did a really good job when she circled back around on that one. And she didn't say it like this, but this is kind of what she meant, is like, they didn't think they were retaliating when you think they were retaliating. Like, are you saying that they should have been like, hey, we should preserve these messages since we are currently retaliating? Like, it just didn't add up. I literally wrote down, like, I know you can't read my handwriting. I literally wrote down, Lyman hates this argument. Mm-hmm. He just had a look, and maybe he's like, I'm probably going to grant some summary judgment, so there's not going to be a trial, so who gives a shit about an adverse inference? But you could tell that he was like, They really hung the whole, because part of what you have to prove is that there are, in fact, messages that are missing. And that's a really hard thing for them, because like if you compare it to that Megan Thee Stallion case where she did get exactly this and then she ended up winning, the one from last year, it's because she had the message right before. And it was like, hey, we're talking about whatever. And then all of a sudden the messages stopped. Like it literally stopped mid-conversation. Mm-hmm. So she's like, oh, clearly there was a conversation happening, but they didn't have that here. They hang the whole thing on the fact that they got in discovery communications between, was it Nathan or Abel, to Sage Steele about whatever this TikTok is that Sage Steele made. And they're like, well, they did it with her, so how do we know they didn't do it with other creators? I was kind of annoyed that nobody on the Wayfarer was like, she's not just like she's a journalist.
She's a journalist.
It's different, right? That doesn't mean they're talking to Ken's and all these other people who got subpoenaed. But it's a very tenuous argument.
And he was saying that you haven't identified evidence to suggest that there was something in there that was helpful for you. Right? Like, I think Garofalo said that too. It could have been the opposite. It could have been nothing in there.
Yeah.
And so there has to be something that shows that potential evidence was helpful to them. And how could they know that there was going to be this retaliation claim when you're saying the triggering event is this protections document that defines a new form of retaliation? And they did talk a little bit about how Lively uses this phrase. It's a new form of retaliation. And I don't think that had much traction with the judge because, I mean,
no. Bruno tried to, like, at one point, and I thought he was good. I bet with a little bit more experience, he's going to actually be quite good.
Yeah.
You could tell that he really had command of his issue. He just didn't have terribly great facts for it. But he was trying to explain, like, let me explain to you how Signal works and like the auto delete. And the judge asked 0 questions. How that technology works is the whole ballgame when it comes to those motions. And he was like, nah, I'm good.
Yeah.
So I think they were just like, yeah, we'll do it. But
I don't see that one as winning.
Oh, we forgot defamation.
Oh, defamation. Oh yeah, the whole thing about Friedman.
I'm looking for like random things I wrote down. Some of it I don't even know what I meant.
The defamation stuff that came up had to do with essentially Brian Friedman's statements in December about this case. And they were hung up on the fact that the statements that he made were not opinion, but were false statements because he said things like, she has a bad intent to, she's making it up, or I don't actually know.
She's trying to ruin his life.
She's trying to ruin his life.
Her motivation for filing the lawsuit.
And there was a quote that was good. I have to find it about like the consequences. If Friedman can't speak about his client, this deprives accused of publicly denying claims brought against them. Yeah. It's a constitutional free speech issue, frankly. And I thought that was actually pretty effective. Shapiro raised that one.
Yeah, but I thought the judge did a good job of asking the question. Like, I do think it's important to hear like what the counter argument would be. And he did a good job of saying, isn't there a difference between saying, the plaintiff's claims have no merit, my client's going to be vindicated, and saying she made all this shit up to get revenge, she's a terrible, horrible person. Isn't there a difference? Now, Shapiro was like, no, there's not, because defending your client is defending your client. And they got into this back and forth about how much is this case like the E. Jean Carroll versus Trump case. And I thought she did a really good job of distinguishing it, because that was, remember, about what Trump said about E. Jean Carroll and how that turned out to be defamatory, and like, weren't those kind of the same, kinds of thing. I've never met this woman, whatever. And I thought Shapiro did a really nice job of saying what's different about it is that this person is an advocate. Mr. Freeman is an advocate, and it is his job. Because the judge said, would it be different if it came from a PR person? And she said no, because again, they advocate. So I thought she did a good job of like, because I think it's important that we don't just knee jerk say, because there are lawyers out there, like, what if she was somebody that you were like, this woman was wronged, and then they got some scumbag lawyer who went out there and said all kinds of horrible things about someone that you thought was telling the truth, right? There has to be some category in which they're not protected. And I think he tested that out, but I think she answered it quite well.
I think she did too. I mean, essentially she was saying like, this is his opinion about what his client's being accused of, and he should be able to make those opinions in order for the accused to assert their denial. And that, I mean, I think that was a pretty good argument.
And she, at the end, was it Hudson?
I think it was Gottlieb who talked about defamation.
Oh, it was Gottlieb. I'm just looking at the rebuttal. At some point, the Lively side, because they were arguing about fact versus opinion, and at one point when they got to the end, they said, well, this is a mixed issue of fact and opinion.
Because they wanted a jury.
Because they wanted it right. So like, if it's a fact issue, it goes for a jury. If it's an opinion, it stops here. And they tried to argue that it was facts, but then at the end, they're like, well, maybe it's mixed.
Yeah. And they were saying, well, see, these make it look like that she fabricated her allegations. But I think it falls pretty squarely in opinion, but
yeah,
we'll see.
We took so many notes.
We're going through all of them for you. Just so you see, can you even see pages and pages? This is all text.
Okay, so the judge asked 2 questions at the end. He was like, here's my questions. It was 1 for each party.
Oh, yeah.
And those are pretty telling, because he's telling you what he wants to hear. Okay, so you get to talk about the one that you think was bullshit.
Which one? The first one?
The MJOP. What shouldn't I consider?
Yeah. Okay,
because you have feelings about that.
Yeah.
So he asked the Lively attorneys. So in the offer letter, which he is like, that's the one that I know for sure is enforceable, that gave Lively a bunch of rights to approve things, right? Like, she can approve the wardrobe changes, or she can approve, like, if they change her character, she can approve it. And he said to the Lively people, was there ever a circumstance in which her approval was not given? And the way that Gottlieb answered it was, when she asked, they said yes. And that's really big for a lot of different issues. But the judge was like, I want to make sure I understand that this agreement was followed pretty much to the letter, because he knows he can rely on it.
Yeah, I thought that was significant. And then his last question to Wayfair was, in the reply brief to the MJOP, the Wayfair parties argued that the judge should not consider evidence that's not reflected in the complaint. So remember, in an MJOP, it's equivalent to a motion dismiss. You just look at the complaint. You don't look at any evidence. And when Lively responded to the MJOP, she incorporated by reference all of her evidence to the MSJ, and she included new allegations that didn't exist in her complaint. And so this kind of stumped Ellen a little bit because, and frankly, I thought it was a little bit of an unfair question because she responded the way I would have responded, which is, Your Honor, this is an MJOP. You can't consider any evidence outside of the complaint.
Right.
And he kept pressing her to say, no, I want you to tell me specifically which evidence should I not consider that they included that you say I'm not supposed to consider. And so she struggled a little bit with this, as I would, because she was like, well, I mean, there's an allegation, there's a new allegation about conduct by Heath. And that wasn't in her original complaint. Right. And so you shouldn't even consider anything about that allegation because it wasn't in her original complaint. And it wasn't a satisfactory answer, at least from the expression of the judge and what he said afterwards. It didn't seem to be satisfactory to him, but honestly, I don't know how else he would have answered that. Because you should not be considering evidence full stop right. in an MJOP. So I don't know if we were all missing it or not, but the specific statements were something about pre-production decisions that Heath made, and this right. phrase birthing
birth
the movie or
right.
something, that suddenly that's also a basis for harassment or discrimination. And so they were like, you shouldn't consider those because those were not allegations in the original complaint. And I think that's probably fair, but for some reason that didn't seem to be what the judge wanted.
I think what she probably wanted to say was, that's not really my problem. You're the one who decided to hear both of these things on the same day. I think she probably wanted to be like, well, if you'd let us argue the MJOP before we got to the MSJ, this wouldn't be very hard. But obviously she can't.
Yeah.
Say
which
that.
They should have. I mean, I still think that they should have. I feel like it would have been easier if the MJOP was decided.
But I also think it could be a signal that he's like, you know what, let's
clean it all up.
Let's clean it. I just found in my notes, it was relevant to retaliation, I think, but this was a piece of evidence I didn't know. Apparently, Leslie Sloan, when she was deposed, testified that it is standard PR practice when you're talking to a reporter to identify that there's other negative stories out there. In other words, the fact that Abel or Nathan may have told a reporter, hey, just so you know, there's a bunch of stuff out there about Lively. You probably ought to read it. Leslie Sloan apparently testified that that is standard PR practice, which is important. That doesn't mean it can't be retaliatory, but it dilutes it a little bit. I didn't know that. I don't think we've seen that yet.
Yeah. I'm trying to think of
y'all want us to add Katie in here? She's texting us.
Is she here?
She said we can add her and she can give you more
she can give you
non-legal color.
Yeah, she was closer to the attorney, so she's got some mannerisms.
Yeah, she saw all the body language we couldn't see. Okay, we're gonna invite her. Y'all, we are all so tired. Katie was up at 5.
I haven't slept.
This one really hasn't slept. I slept a little bit, but not a lot.
I took a red eye and I'm not very good at sleeping on planes.
I had dinner with a friend of mine last night who lives in the city and I never get to see him. So I was like, let's have another drink. I'm like, all right. I came back to the hotel at 11 and I was keyed up because I knew I had to get up early. And so I don't think any of us slept worth a shit.
Oh, yay. Hold on. We're going to add you. Boom.
Hello.
Hi, dear.
What have you guys talked about so far? Just all of the legal stuff?
Literally everything.
Everything. All the boring legal stuff.
All the boring legal stuff. So you can tell everybody about your impressions of the mannerisms and the cool Chanel shoes and all that good stuff.
Yes, let's go through.
We're gonna make you center stage.
Yeah. Oh, okay. I'll be center stage.
Wait, how do I make you center stage?
Is it the grid?
This
one. Like that?
There's other screen. Yeah.
I'll figure it out. You keep talking.
So what was happening was, because of the way they filed us all into the court, there was even though we were front line, they kind of lined us up in those back benches. And so as they continued to add people in, Sabi, who is an amazing follower I met today, she got placed over on the side, this other side, on the right side that I was on, which is the opposite side from NAG. I call you NAG, not NAG, because I can't stand I think it's derogatory to say NAG for some reason. So I say NAG because I like it better. And LGA. So I was on the other side. But Sabi was placed up a little bit higher, and she turned around back to me and she looked at me and she goes, "Do you want to swap?" Because she was kind of in a good seat to see. And at first I was like, no, like she's here too. She waited on, like, we all, you know what I mean? She wants to see it. And then I was like, no, you know what? I flew to New York for this. I would love to. And so I'm like, you know what? Yeah, let's switch. So I ended up moving my way all the way up to where I was parked, like right up, like I was so close that me and Kevin Fritz could probably like do this because it was like I could, yeah, it was like front row. All the people were there. But because I was so close, I think you could get a read on the body language and the way that people spoke a lot more than you can get from when we're reading the transcripts and we're reading through things that are just, does that make sense? Like those things. I can't, where's the chat? I want to see the comments. Perfect. Hi. Okay, I can see the comments now. Where like you can't really pick that up when you read a transcript or pick that up when you're reading through somebody's like writing. And there were definitely some lawyers that are probably good paper only lawyers. No offense. And I'm not, I will say I'm just a lady. Like who, like I don't know anything. I've never been to a court hearing before like this. I've seen them on TV, but I've never been to one in person. And I feel like although they are all like obviously have accolades and they're all impressive, you can definitely pick up on how confident they are in certain arguments and how wavering they might be on certain arguments and where some of their fallacies might be just based off of body language and the way that they spoke. So just from my notes, I'll start off by saying like so for the lively sides of the plaintiffs, they were closest up towards the bench with the judge. I will say the people on the wall were giving off bad vibes. I think they were senior associates. They weren't high enough to be on the main bench, but they were all kind of like, they kind of had this kind of face to them, like, and you'd look at them and go like, "Hi, how's it?" And like kind of give them a smile. They just weren't giving anything back. There were smaller associates up in the right quarter. They had no idea what was going on. They had no expressions, nothing on their face. They didn't react to much. They looked like they were falling asleep half the time. They didn't care. They were up in the jurors like bench along with Stephanie Jones's lawyers that were up there. It was like Kristen Toller and Marin Shaw, and somebody else that I have not yet identified. However, Lively's bench across the board, Hudson, I'll say, was absolutely, I would say I'm very impressed by Hudson. She was an impressive lady. The way that she spoke so eloquently and the way that she was, let's be honest, she was given like a crap hand, right? Like she doesn't have a good argument. But imagine you were put on a debate team and you were like, well, you drew the short end of the stick, but you got to do your best argument for what you have. She did such a good job. So she didn't waver with her words. She was very clear. She was very confident in the way that she carried herself. She was very matter of fact. And she was also very colorful and emotional with her language, much like she is in her letters. And that was impressive to me. So she was one that I was like, I like her, even though, you know what I mean? I don't agree with some of the things she's arguing with. I like her because I think she did a great job. Michael Gottlieb, I wrote down frustrated and tired. I think that the way that they did arguments, each of them had 3 lawyers argue different parts, and I'm sure they went over all this part. But by the time Gottlieb got up to make his argument, prior to, he was just kind of head down. He was just writing some stuff, like he was just hanging out there. But as soon as he got up to make his arguments, he was frustrated because he didn't have a lot of time. His other counterparts took up a lot of the time that they had. So he was having to rush. And I feel like he was having to work through a lot of it. And then when the judge would ask questions, he wasn't able to fully get out what he needed to because he's kind of, he's rushing. And so when they went through, so that was what I had for Gottlieb. Bruno looks like a frat boy that, in my opinion, he seems like a frat guy that got a job and he's been doing it for a decade and seems to be pretty good at where he's at. He made his arguments. He was clear with this thing, but it was pretty mid. Like there wasn't anything like insane that was like, oh wow, he's such a great arguer. In fact, there was an argument he made on the rebuttal that I was like, what are you doing on this rebuttal? And I'm sure they've already talked about it. It was when he was talking about prejudice. Yeah, the text to rebuke, they claim those as like, my notes are scribbles. I need to figure that out. But we're talking body language. We're talking what we sell. So Bruno was kind of mid. Who else for Lively's team? The rest of them were kind of quiet. Who was their third person that spoke? Help me out. My brains. You guys went away. I thought. It wasn't. Nope. It was Bruno, Gottlieb, and Ed Hudson. I went over them. Okay, I did all three. So then let's talk about the Wayfair side. So the Wayfair side, I don't know if they had senior associates there. They had people in the back row that was parked in front of the left side of the benches. So like if you think about, here's the two sides. I was on this side. They were like parked like right here. It was just the people who were working on background. Kevin Fritz actually sat back there. So they were quiet. They didn't really do much other than like help support his lawyers. So Kevin Fritz, I wrote down for body language. He was one, if not the only lawyer that during the hearing broke face, if that makes sense. Like a couple of them would smirk because there was a couple of like zingers where like everybody would laugh at stuff. And during those zingers, the teams would turn around, and obviously Wayfair's team would smile, but other than that, when there was like weird arguments being made, or like when the Lively team would bring counterparts, Fritz was the only one that'd be like kind of, but it was slight, and it was just because I was trying to pay attention to that, if that makes sense. Everybody else was like, this was their faces, literally, like acted like it was the most boring thing in the world. So he was one of the only ones to make break face. Ellen Garofalo, I feel bad. I told you guys that about her. So she was wearing these. Well, I won't say the bad part, but she was wearing these Chanel shoes that were gorgeous. They had a thick heel to them, and they were pretty high, because I think she's like 80, right? She had a good 2-3 inch heel on, you guys. And I could tell her only tell for being nervous was she was lifting her heels out of her heels, if that makes sense. So like you could see her foot pop out of the shoe. And then I noticed all the lawyers did this, but when they were getting nervous, they would put their hands on the podium like this and they would lean on it. But other than that, if they felt, you'd see them ease up when they were more like confident, and then they'd be flipping through their papers. So we had Ellen Garofalo. And Ellen Garofalo, her arguments and the way that she argued, I think she is better on paper. And I think that it's because she needs time to compute and verbalize her thought. And unfortunately today they were limited to an hour. So it's not that I don't think I think she's there, she's got it, but she just needs some time to get it out. And because of that, it made everything slow down a little bit, which kind of, I think, weakened her position to be able to argue those claims. Then we had Shapiro. Shapiro for let's get to Bach first. Let's talk about Bach. They had Bach argue the sexual harassment and retaliation claims. And I know they've probably already expressed their opinions. LGA and NAG did, but he said a few things that I think were a little bit off-putting because it's coming from a white man, like saying it. And even as somebody who has an open mind, it was a little weird. Like one of the things that stuck out to me that he said was like, some of these low-level concerns or like low-level issues that she had when he was talking about like the kissing, and now we've rephrased it to nuzzling. No longer biting and sucking the lip, by the way. We're now nuzzling. And so it just kind of was like, I've never really heard him speak. So it was just interesting that they had him argue those, but I don't know what they've decided. So, and then Shapiro, I think, was the most surprising out of all of the lawyers. Shapiro was nervous. She was shaking, like physically shaking, like her body was shaking, her hands were shaking, and she was very visibly nervous the entire time. Mainly during her, like she seemed okay during like her initial arguments, but as soon as she had to start arguing about Brian Friedman's defamation claims and like those like for like those issues towards the end, when she started to argue about it, she'd start to shake. And it obviously her words would stumble. The judge would ask a direct question and and she had an associate that was like literally speed writing and handing her notes. And then she'd take the note and she'd go, and then at one point in time, she took the note and she like pasted it to the screen. And I was like trying to read it, see if I could read it from afar. And she'd read off the note because she was nervous and she was trying to get the points, and he would ask specific questions and maybe she didn't know top of mind. But for as sharp as her writing is and as sharp as her filings have been, I know that she was added on more like late to this, but I think I expected a little bit more, especially because I've heard about her, like how impressive her history is, right? So that was just something that I was like, I'm not really sure what to take of that. I did do a silly thing where if anybody wanted to try and make eye contact with me, I gave them a wink just to see if they do anything, and nobody did anything. They just let me wink at them. I don't think I told NAG that. I did though. I just was like, and if anybody made eye contact, I go, see if they did anything, and nobody did anything. It was just to be a little silly goofball. I mean, I was literally a bit like a 6'2" blonde chick wearing cheetah print overalls in the front row of a court hearing. I don't know how much more I could have stood out. I almost wore my green striped sweater and I didn't.
It was awesome. She was wearing
It was awesome.
She was wearing a lace long sleeve shirt underneath a cheetah print overall with like something that looked like Doc Martens maybe, or one sort of similar. And her notebook, floral notebook.
It's strawberries, but I would tuck it into my overalls. I needed utility.
With the
does
pen,
nobody use utility like my strawberry notebook? I just tucked it into and I'd walk around with my pens in.
I loved it so much. I look like a boring lawyer with my herringbone jacket.
No, you're not boring. You guys were that's how the game goes. But I looked around and I was like, it's a sea of black suits, and everybody was like, which I get it. If you do this day in and day out, you just have to dress the part, right? And do the thing. Like I get it. But it's just so interesting to me, like I don't know, that you like it's like washed out the personality. Like everybody, like you can't tell, which I'm sure that's a strategy too of why people do that. But I will say too, they took a break halfway through at like around like 11 a.m. here, like a 10-minute break. And a lot of people ended up leaving the courtroom. And I noticed that a lot of like people that were coming to like press and like the people who were watching left, but the lawyers stuck around to talk to each other. And so I was telling them earlier, I was like, yeah, so I just stuck around to listen to see what they were talking to each other about. And I would watch, I'd sit there and I'd just look. And then I started noticing that they're like, oh shit, she's watching. Oh, fuck. Oh no, we shouldn't be. And so they didn't like that very much. They didn't like that I was listening to them talk. And I was trying to be a little more discreet about it, like do. But they knew. So Brian Friedman and the Wayfair parties ended up exiting pretty early. They realized they weren't going to get the privacy that they needed to discuss amongst the team. And then the lively parties stuck around, but they tried to hide in the back corner. And then Ezra, I kept watching Ezra, but she clocked me real early on. She kept at it, but she would do this like this and try and like cover what she was saying like this. But the main words that I would get out was the extraterritoriality thing. They were very concerned about that. So that was mid-break. But I guess I didn't get a chance to watch your live, so I don't know what you guys covered pretty much everything. You talked through all your points. Anything you guys had for me or that people were asking about when you said they were asking for me?
Well, we went through all of our notes. I didn't read every single comment. I tried to look at the comments, but we thought you could provide the other outside perspective. So we were really listening in on the arguments and focused on where those were going to go with the judge and watching the judge. So hearing your perspective on the lawyers was good.
Yeah, people were asking us, of course, like me and LGA, like, what do you think? And what do you think is going to happen? And we're like, I have no idea. I mean, none.
Well, I heard people making conclusions, like jumping to conclusions, like, oh, this is like as soon as we walked out, like, oh, this is definitely going to trial. I personally didn't I don't, and again, I'm just but I felt like he seemed to ask a lot of questions in regards to, hey, so what if I threw out this ALA? What are you guys going to do? Like, if I choose not to endorse or consider that contract valid, her employment contract valid, what it's going to throw out all these claims. What are you going to argue then? And because he kept asking that, I'm like, I don't know. He might be leaning towards that. It might be and then the other thing I thought of, and I don't think I discussed this with you guys earlier, is he had quite a bit of back and forth. Like, he didn't know what he was going to do about the O'Connor and the gravy stock, and those two, and I was like, I'm going to have to go look up and see, because he kept saying, was it gravy stock? They each said it differently. Grave quick. That's what gravy stock.
I have a video, I think on both channels. I think I put it in like the basics or the law school or whatever. It's about like explaining case law. Like, people have been asking me to explain case law. This was maybe like 3 weeks ago. And what I use to describe how case law works are those two cases.
Okay.
And the long and short of it is that, like, Grave Quick was the first case in California on this issue that kind of set the standard. But then O'Connor came along and maybe changed it a little bit. And he's trying to decide, like, which precedent is it that I'm supposed to use? He was real hung up on that.
Well, he kept saying
it's California.
Right. Because, and he kept saying, like, you know, I think, and if I might mix these two up, but he said, like, O'Connor was appellate. And then he goes, so everybody's assuming that he would go with the appellate decision because it's the higher court. But he goes, but I don't have to do that. You guys are assuming I'm kind of going to go with that, but I could go with the Grave Quick, you know.
Well, and he said I have to pick the most correct interpretation of California.
Yeah, and he goes, so and so he kept going back, but he pressed on that for quite a bit, like at least a good, like, with multiple people. And so it was something that kind of came to me later where I was like, I need to look up what that means, because it seemed like it was an important piece.
Go look at, okay, I just found it. It's, well, you can't see that. I have a
it.
video called How Case Law Works is at the top, and it was on December 9th.
Okay.
I mean, I can tell you what I'm wearing, but it's the same shit I'm always wearing. It's pretty much what I'm wearing now.
No, it's okay. I'll find it.
But I remember reading it, and I used those so that might help a little bit. But yeah, I thought that was cool for him to bring up, because when he's talking about these California cases, he doesn't have to follow them if he doesn't want to. They're not mandatory authority for him.
Okay, now my next, so those were not bound by O'Connor. Yeah, I have it all up. Statute, because he was trying to decide between like appellate and statute versus, how to enforce it. So, my other question, and I sent it a little bit earlier, not sure if you've had a chance to see it, but did you see Sigrid McCauley's statement she made outside prior, like before we made it out?
No.
So she made it out prior to all of us. There's a clip that was recorded by Court TV Network, and there was a clip that was recorded by Inner City Press. They are different clips, different statements, but absolutely nothing that she said was mentioned in court.
Huh.
How interesting.
That's interesting. Like, what did she say?
It was a very generalized statement about Justin mentioning orgasms, nothing about Justin talking about his genitalia. Like, it was the most insane.
Wow.
Like, it was very gratuitous. It was I was like, literally none of that was talked about today. I don't know who cooked that one up, but it was insane.
It was interesting to see her in person, because, like, you know, she's a relatively high profile lawyer, but in person, she's just
not impressive in person.
And it's like, I mean, she wasn't there to talk except on the steps.
Right. She sat in the benches with all of us. She sat close to me. I didn't really get a read. She was very neutral. She sat very postured. Her tracks were showing. I gotta cover them up a little bit. I get it. I get it though. I get it.
I do think, I just saw a couple of comments. I think we talked about this the other day. I do think that part of the reason that she's been put in this position is in case some of these motions do get granted, they're going to want to spin it as, well, this is just the law. But you know what I mean? I do think that this is part of a damage control plan for the future, is having her out there so that when she's the one who says it, everyone's like, oh, that's the person who talks for Blake. So, you know, I'm disappointed that she's not taking a more nuanced argument, considering she's a lawyer and she should know better, but
she's paid to do.
Well, and I think I should probably backtrack and say that it's not that she wasn't impressive. I think it's that she isn't as scary as I think she's, or as like, she didn't seem as heavy hitter as I think her reputation is, in my opinion, in person. Does that make sense? Maybe she doesn't like fit that. Yeah. So, other than that, I'm like trying to think, those were pretty much, yeah, they brought up, of course, the zingers. There's a couple of times that they made the court laugh. You know, there was a couple of times that I'm sure other people have hit on but it was, there was one thing that was brought up that had never been said out loud before. And I think I told you guys, I don't know if you mentioned it, but, during Ezra Hudson's explanation of the explanation for her or like the sexual harassment claims, she went through and explained the trailer situation and that kind of what happened. And she said that when Jamie Heath tried to enter the trailer, she verbally said that in Carol's deposition and Vivian Baker's deposition, they both exclaim, and you can look at them, that they say, whoa, 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 no, don't come in this trailer. And I think that is the very first time I've seen something like that, because that's a very clear expressive of absolutely not. And I have never once heard that before until today. I've never seen it on paper. I've never heard it argued. And that's the first time was today. So I don't know if there's a deposition that I haven't read or if there's something that's up there, but it's crazy.
There wasn't a whole lot of press. There was a little bit of press, but it wasn't like you would expect. And I just now was looking at People, and you know how they do that thing where it's like in the app, like you can read this story, and that's the only story. It says in the app, Justin Baldoni's lawyers attempt to dismiss Blake Lively case ahead of trial. Don't even fucking get me started. It's not a dismissal, but this is what the coverage is like, oh, they're trying to take away her right to have a trial. It's like, yeah, by filing a motion that all defendants file. Mm-hmm. Because that's how the law works. So I don't have the app, but if anybody does, you can tell us if that article is BS or not.
Well, I'm curious to see what Sean wrote. I know you said that it was already posted for deadline. I met a guy in line. His name is Sean. He goes, I was like, oh, Sean, where? And he's like, oh, I'm a reporter. You know, I'm here for deadline. And I was like, you are? And he goes, yeah, you know, I got to sign this piece to go write for a guy named Dominic. And I said, Dominic? You mean Dominic Patton? And he goes, yeah, actually Dominic Patton. That's right. Yeah, and I was like, oh, tell me more. And so anyways, sounds like he got the information back to him, whatever he needed.
There's a TMZ story up where they said they talked to Friedman afterwards. I guess they were there. And he says he's not ruling out a settlement possible. Remember, they all had to go to that settle. Well, who was it today that went? Was it Wayfair?
Just Wayfair.
I
thought it got moved to tomorrow.
Well, they're split, so they don't go at the same time. So one of them had this afternoon, and then one of them had.
I saw Friedman walking away, and I think I tried to get a video of it. And TMZ was chasing him down with a camera. So I have it.
Right. That tracks. That does track. I mean, I don't know.
Yeah, 18 seconds of me going, wait, where? Oh my gosh, what are you doing?
Y'all should know about Katie. Katie will walk up to anyone. Like, we're all standing there in the line, and like the lawyers would come by, and we're like, oh, I think that's Bach, or oh, I think that's whatever.
Because they could see you whispering about him. Like you.
Katie goes, Fritzy! And and to his credit, he was like, hey, how are y'all doing? So like, Katie is completely.
I did go Fritzy, and then he shook his hand. I was like, nice to meet you. All right, that's, you know,
he was very nice,
very kind. And honestly, they all were. I will say, Lively's lawyers avoided the shit out of me. I did try though.
Yeah.
Obvious.
Did you go up to any of them?
What?
Did you go up to any of them?
I tried to get Gottlieb on his way out, and I asked him if he wanted a comment. That was one of the videos I got. I was like, Gottlieb, can I get a comment? And he just kept walking like away. TMZ was running after them too. And then Ezra came out, and then Ezra just was like, they weren't talking to anyone. So it seemed like they were waiting for Sigrid. She's the one to do it. They both were maybe instructed not to speak to anyone, which makes sense.
Mm-hmm.
Yeah. Because they didn't even talk to the TMZ camera.
Andy was there, Andying around. I'm sure he's put stuff up already.
Lauren, court of random opinion.
And Lauren, yeah.
And of course, Carol, who made Docket Update.
Carol was great. Yeah, everybody's been so great. It's been so fun and we met so many fun people. What was it? There's John. John was great. Zian, I want to say. Then there's Irma was amazing.
Clark
was there.
Delightful.
Yeah, I think there was somebody kept asking, was there anybody on behalf of Blake Lively there? I think there was a couple of creators. One was maybe MJ. I don't know for sure if that was her. And then there was another creator that I tried to introduce myself to, and she didn't respond. So I figured maybe they didn't want to talk, or it was something. Yeah. So I don't know if that was another person or not, but yeah, that was from my observation.
I think Clark tried.
Did Clark try to get him?
Do you know if Clark got the CDs?
So no, there's still nothing filed, from my understanding.
Oh, that's right. They weren't. That's right. He said that.
Oh, interesting.
So I am in town for another half day or so. I talked to Chris, PR Chris, and I was like, I think I'm gonna be a pumpkin tonight, but maybe coffee, a mid-morning snack of sorts.
Yeah.
Something like that. Maybe check in the morning. I might go down and see if I need to go do another Canal Street run.
Get it, Katie.
Yes.
Katie's a very good shopper. She's on it.
And then if there needs to be documents and stuff that needs to be picked up, now would probably be the time to do it, unless we rely on people who are here locally. So if they're there, I can always stop by tomorrow. I'm more than happy to do so, but might just be good to go. I was always wondering, do you know much about the court sketches? She was impressive. That woman,
we couldn't even see her.
Artist.
There was a sketch artist today?
Yeah.
Yeah.
Oh, I didn't see that.
She was sitting in the jury box. Oh, she was gorgeous. She was so passionate. She was so into what she was doing, and she had the little finger gloves on, and she had all the pastels, and she was just over there like a wizard.
I wish I saw that.
And then she had like what do they call them? Like binocular thingies to see the judge closer. She put those on, and then she'd do his thing. But I was like, can you buy those? Do you have experience with that?
I've never done it before.
Yeah. I think
Never
it's
cared.
You've never cared. Not that it's like, when would I ever need, just as just as like a weird thing to hang in your basement that some random stranger could be like, what's that? And you'd be like, I don't know, some random lawyer from 2026 that I went and saw in person one time.
I don't know if it's the court has a relationship with artists, or like,
because I don't think it's like a party and put them in articles, right?
Yeah.
I think because, I think they have to let them in there because they have like rules they have to follow about what they can do.
Yeah.
But we didn't even see her.
Yeah, I didn't even notice her. But that's cool.
Yeah.
I hope to see the sketches. Maybe we'll be in them.
I'll ask some questions about, but I thought it would be interesting just to even if, I don't know. Yeah. Just thought I'd ask because you guys got the experience, but I'm already hungry again. I'm jonesing for what's my next meal. I'm thinking ramen or like something like.
You said pizza slice, and I'm in New York,
You
so
did.
Nice. Okay.
We came
We're
back
close to
Chinatown,
so I was like, ramen has to be.
Oh yeah, that's true.
Insane.
We all we were so hungry. We were like ravenous. So we just ate, and we ate our food, and then we're like,
a mac and cheese bowl. And we were literally, and we were like taking. It was so good.
Yeah.
But yeah, I my video. Somebody clipped out my video already of me saying hi to Brian, and the sun is coming in past his head, just right. And somebody's like, "Look at the sunlight beaming over and you're like, "Okay, come on." Like, it just shows you how good. And you're like, "All right, we're being a little like, okay,
Yeah.
like, come on, let's not glorify too much,
I was really surprised at every single person. Like, I thought some lawyers, like some of the associates or the lower level lawyers who aren't arguing won't go. Everybody went.
Mm-hmm.
And then some.
Mm-hmm.
The
lawyers
I'll
came.
give you a 1 minute recap as best as I can. We're getting you guys are getting at the 2 hour mark. Holy cow.
Yeah.
Oh God. No wonder I'm so tired.
Yeah, I'm pretty wiped, but
okay. Yeah. Maybe we should call it.
Guys.
Call it.
We'll both post this.
This
on
will
our
go
account.
on YouTube for the replay.
Yeah.
So thank you, Katie, for joining us at the last minute. Thank you all for coming and watching us. We didn't give you any warning,
very
and you
full.
showed up. There was at some point like 7,600 of you, I think,
my
if
God.
I was looking correctly. And I think it's time
Many?
for me to crash. Yeah.
Just know that like the system worked today.
The
like,
system worked.
The judge was great. All the lawyers did their clients justice. Like everyone, like it was good.
Something
was-
I told Sabi and Molly in the elevator as we were coming down is I said, it feels really cool to be. I was sitting there at one point going, I'm exercising my right as an
Mhm.
American citizen
Mhm.
to come in and do this. Like what?
Yeah.
And it feels really cool to be able to do that. You know what I
And you
mean?
can
You're
do
like,
it
wow, I've
for any
never
case.
done this
Yeah.
before. And it was cool.
Yeah.
So
Yeah, Sabi was saying with her friend, they're like, we just kind of realized today, like we can just show
Yeah.
up to stuff. And I was like, yeah, you kind
You
of
literally
can.
can.
Like goes. I mean, it's
Yeah.
super fun to watch that kind to just dip in and see stuff.
Mhm.
But yeah, we all exercised our civic duty and our constitutional rights and all that stuff today, which is fun.
Yeah.
hell yeah.
And thank you to Lauren for sending people over our way. We hope this was
Yes.
helpful. I'm sure there will be more content to come out of all the unsealed documents yet to be reviewed. So more to come.
I think we're all going to digest and probably like have some follow-ups
Mhm.
maybe tomorrow or something. But
Yeah.
Somebody just
We
said
wanted
I'm
to-
the blonde chick with
Wanted
the
to get
big
it to you guys as quickly as possible.
yeah, we wanted to take a nap, but we didn't.
I really wanted to take a nap.
She really wanted to take. She was on a red eye. She doesn't sleep.
You
for,
haven't
like,
even
24
slept fully.
I haven't
so you really
slept
wanted to
since-
sleep. Like
Yeah,
not a nap,
exactly.
a sleep.
Yeah. Exactly.
Oh my god.
All right.
All
On
right.
that,
Thank you
Thank you.
guys.
bye. End stream.